Oh no. Dicey. The classic account given by Dicey. The doctrine of the supremacy of Parliament. Pure and looting, as it was, can now be seen to be out of place in the modern UK. Ooh. Nevertheless, the supremacy of Parliament is still the general principle of our Constitution. Not yours, ours. It is a construct of the common law. Of the commons. The judges create this principle. Other judges. If that is so, it is not unthinkable that circumstances could arise where the courts may have to qualify a principle established on a different hypothesis of constitutionalism. That's ism. In exceptional circumstances involving an attempt to abolish judicial review or the ordinary role of the courts, the appellate committee of the House of Lords, of a new Supreme Court, may have to consider whether this is a constitutional fundamental which even a sovereign parliament acting at the behest of a complacent House of Commons cannot abolish. Got it? Therefore, Lord Craigslist, Hope of Craighead, similarly described the principle of parliamentary sovereignty as having been, and I quote, created by the common law, that is, by the judges. Baron Ist Hale of Richmond, that's Richmond, added, the courts will treat with particular suspicion and might even reject any attempt to subvert the rule of law by removing governmental action affecting the rights of the individual from all judicial scrutiny. 35, you were 34. Welcomed in some quarters. These observations have also been described by one acerbic acerbic academic commentator as unargued and unsound, historically false and jurisprudentially absurd. No, as 36-year-old, no authority was cited to support them, and no detailed reasons were given. I cannot, for my part, accept that my colleagues' observations are correct. It is true, of course, that the principle of parliamentary sovereignty cannot, without particularity, be ascribed to a statute, and the historical record in any event reveals no such statute. But it does not follow that the principle must be a creature of the judge-made common law, which the judges can alter. If it were, the rule could be altered by statute, since the prime characteristic of any common law rule law is that it yields to a contrary provision of the statute. To my mind, it has been convincingly shown, 37, you old fart, that the principle of parliamentary sovereignty, EI, has been recognized as fundamental in this country. Not because the judges invented it, but because it has for centuries been accepted as such by judges and others officially concerned in the operation of our constitutional system. The judges did not by themselves establish the principle, and they cannot by themselves change it. This is not a conclusion which, thus far, I regret for the reason very well expressed by Professor Goldsworth. And now, hear ye. What is at stake is the location of ultimate decision-making authority, the right to the final word in a legal system. If the judges refuted the doctrine of parliamentary sovereignty by refusing to allow Parliament to infringe unwritten rights, they would be claiming that ultimate authority for themselves in settling disagreements about what fundamental rights people have and whether legislation is consistent with them. The judge's word, rather than Parliament's, would be final, since virtually all significant moral and political controversies in contemporary Western societies involve disagreements about rights. This would amount to a massive transfer of political power from parliaments to judges. Moreover, It would be a transfer of power initiated by the judges to protect rights chosen by them, rather than one brought about democratically by parliamentary enactment or popular referendum. It is no wonder that the elected branches of government regard that project with apprehension. I agree. The people have not repelled the extraneous power of the papacy in spiritual matters and the pretensions of royal power in temporal, in order to subject themselves to the unchallengeable rulings of the unelected judges. A constitution should reflect the will of a clear majority of the people, and a constitutional change of the kind here contemplated should be made in accordance with that will or not at all, as was put by a member of Parliament in 421. The judges are judges of the law, not of the Parliament, hang. God forbid the state of the kingdom should ever come under the sentence of a judge. Thus, in 39, now you old. Listen, for those who have followed me this far, we reach these conclusions. We live in a society dedicated to the rule of law, in which Parliament has power, subject to limited, self-imposed restraints, to legislate as it wishes, in which Parliament may therefore legislate in a way which infringes the rule of law, and which the judges, consistently with their constitutional duty to administer justice according to the laws and uses of the realm, cannot fail to give effect to such legislation if it is clearly and unambiguously expressed. Is there, then, a vice at the heart of our constitutional system? Some would answer that there is not, although since Parliament has their radical power to legislate in a way that infringes the rule of law and fundamental rights, it can in practice be relied on not to do so. No doubt the prospect of legislation discriminating against blue-eyed babies or red-haired women can be effectively discounted, but it is not at all hard to envisage legislation infringing the rule of law in less obvious ways, as, for example, by legislating to preclude any legal challenge to the decision of a statutory tribunal, as was proposed in Clause 11 of the Asylum and Immigration Treatment of Claimants, etc. Bill 2004, later withdrawn, 40. The Constitution should, ideally, give protection against minor aberrations as well as those which are gross. Under the constitutional settlement bequeathed to us by the Glorious Revolution, a substantial measure of protection was given by the requirement that crowns, lords, commons, each of them powerful independent players, should assent to legislation before it became law. As Victorian Chief Lord Justice put it in 646, the Constitution is lodged in the sacred deposit of sovereign authority in a chest locked by 3 different keys, confided to the custody of 3 different trustees. 41 UR. Referring to these 3 different trustees, the same author continued with what now seems extraordinary precedence. One of them is now at length, after ages of struggle, effectually prevented from acting alone. But another of the 2 is said to enjoy the privilege of striking off the 2 other locks when, for any purpose other than its own, it wishes to lay hands to the treasure. Thus, today, as we know, the legislative role of the Crown has been reduced to mere formality, and under the Parliament Acts 711 and 749, the powers of the Lords is one of the relatively brief delay and not denial. It was originally envisaged, envisaged, that the 1911 Act should be used to effect not only major constitutional changes, but so used to enact the Government of Ireland Act of 714, the which won Church Act of 714, and the Parliamentary Act of 749 itself. But the 749 Act has been used in recent years to achieve objects of more minor or no constitutional import. The War Crimes Act 91, European Parliament Act 99, Sexual Offenders Amendment Act 2000, and the Hunting Act 2004. This is the elective dictatorship to which Lord Hailsham, out of office at the time, famously referred as mentioned in Chapter 2. Thus, our constitutional settlement has become unbalanced, and the power to restrain legislation favored by a clear majority of the Commons has become much weakened. Even if, exceptionally, such legislation were to infringe the rule of law as I have defined it. Hike, take a hike.